Hello, and welcome to another edition of Coffee Talk with attorney Brian D. Lerner. This particular episode, I'd like to talk a bit about the last will and testament. I have a lot of people who come into my office. They go something to the effect they want a simple estate plan. All they want is a last will and testament. They just want to boom, 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 get it over with and sign here, sign there, and walk out the door and have it done. And unfortunately, it's not usually that easy. There are a lot of, and even if you do this on your own, okay, I mean, you need to be aware of certain things. So if you go to nolo.com or whatever and or go down to the local bookstore and pick up a pre-printed form where you put your name in here and fill out the property and this particular section, you need to be aware of the limitations, and you need to be aware that just having a last will and testament normally is not a complete estate plan, and normally is not going to protect your you want. Now, first of all, a complete estate plan should also include documents if you become incapacitated, not if you just die. Now, you understand a last will and testament, it goes into effect more or less when you die. Um, but what about if you get in an accident tomorrow, go in a coma or go in surgery, or you have some other situation where you're not, uh, you haven't died, but then again, you don't have the capabilities at the time to sign anything or convey your thoughts, or you're not even conscious. So, along with if you're going to do the last will and testament only and not a living trust, that's okay in certain circumstances, but you should also have a durable power of attorney for financial management, and you should have the advanced healthcare directive. Okay, you should have both those items. Um, so going back to just the last will and testament, another issue that comes up a lot is like one person, let's say that you're married and you make like a reciprocal will and or a will contract, where essentially one person says, I will do this if my spouse, when she dies, does this type thing. Okay, that would be referred to as a will contract. And that by itself is not the best idea to have. Okay, number one, it's really hard to enforce it after you would die or after your spouse would die as to what was meant. Next, there's all kinds of issues that might happen in regards to the type of properties you're agreeing to exchange or bequeath. Um, a lot of times, uh, if there's community property, you cannot bequeath your spouse's share of community property. That is that person's property, and unless they agree, there's going to be some issues. Okay. Now, depending on the value of the estate, um, while you might be able to get away with just doing a declaration of a small affidavit for the estate, if it's basically more than 150,000 and all you have is the last will and testament, it's going to probate. Okay, and by going to probate, it takes time, it takes money, it takes hearings, it takes going to downtown LA and making several appearances. So there's all kinds of stuff that might have to happen depending on the value of the estate. So, a lot of times if you don't have any real property and or all the assets are less than 150,000, then you can get away with just having a last will and testament. But in all other cases, you really should consider the living trust in lieu of it. Um, but even though I say that, still some people want the last will and testament. So just make sure that if you're going to alter it or change the last will and testament, that you do a codicil, a proper codicil to show it, and that the codicil is properly done so that it explains clearly what it is you're changing. I mean, sometimes people will want someone else to get something instead of the person in the original will, but they don't make it clear that they're taking out the original person and putting in a new person. Okay. Um, there's also tax issues with the last will and testament. And basically, the way you can look at it is once you would die and everything goes to whomever it goes to, whether it's in probate or not, there's going to be some significant tax issues. There could be gift tax, estate tax, all kinds of issues. Now, with the living trust, a large portion of the estate could go in a survivor's trust or a sub trust, and there might not be hardly any taxes. And then once the surviving spouse would die, 15 years later or whatever, then the tax at that time. So when you do only the last will and testament, do be aware that there are significant tax issues that might come into play that would not otherwise come into play if you did the living trust. And while the one that's going to make the last will and testament, will have passed away and really don't care about the tax issues, it's the people who get your property who then have all the tax issues. And maybe your daughter or son is struggling, and now they get whatever property you wanted, but now they have to pay $100,000 in taxes. So it's not just they'll take care of it some later time. You do want to take that into consideration. Okay. And one thing you don't want to do is really a joint will. Okay, that basically is a single testamentary instrument consisting of the wills of two or more persons. You just want to make an individual will for each person. So if your spouses do a last will and testament for spouse A, and then spouse B does his or her own last will and testament. Okay, that way it's clear. We don't have to worry about what the intentions were. It's all specifically listed on there. Okay, so lots of general things to think about when doing a last will and testament. If you like the video, click like, subscribe. You can also call my offices in Los Angeles and Long Beach. I'll be happy to give a free initial consultation, let you know what can be done. Okay, more on the coming videos.